Om Prakash ji, we are live.
Okay. So, good evening, everyone. Today we have assembled here primarily on this portal for a very significant issue. The recent time everyone has witnessed. This is regarding the recent UGC equity bill, which has created some stir, especially in the North India, and primarily the Gen Z generation, the students actually they were in the forefront. So there have been a lot of issues, regarding the same. So now I would like to invite Dr. Bhagis Upadhyay, who is going to speak on this issue. And if I have to introduce Dr. Upadhyay, he teaches at NLU Ranchi. He teaches law. His specialization is in criminal law, international law, public policy. And also, he has several publications in national international journals, also delivered a number of lectures, in fact, in different reputed universities in the country. So I think an NRS, National Reconstruction Society, who is organizing this talk, is primarily organizing such discussions on the public policy time and again. And this is just one of the addition in this direction. So primarily the idea is that to have a discussion on the non-partisan perspective, having a balanced approach in a non-partisan perspective. So in this regard, now I invite Dr. Upadhyay to speak his mind. Yeah, Dr. Upadhyay, it's all now
Yes,
for
sir.
you.
Thank you, sir. Thank you, sir, for your kind words. Now, so UGC Equity Regulation 2026. Nowadays, it is. I would not like to call it a controversial issue because we belongs to a academic background, and rather than I would like to say that a debate is going on. Though some person, those who are misguided, are opposing or supporting by this side or by that side. Why so? Because there is what I found in last 1 month, what I found after the 13 January 2026, what I found especially that there is a mixed reaction regarding the UGC Equity Regulation 2026. Now there are two groups, and both groups have their demand and claim and interest. Okay, so when we are talking in the sense of policy, so the policy of the state, which kind of policy of the state we want. So here the and regarding the enactment and legislation, so there is two approaches. One is inclusive and another one is exclusionary approach. So, and if we talk about the Constitution of India, especially with respect to Article 15, which opposes any kind of discrimination, any kind, whatsoever the discrimination you found on this earth. So our forefathers are wise enough that they have included every kinds of grounds in Article 15. And but unfortunately, uh, now it's my own word. Unfortunately, some of the person who have their vesting interest, political vesting interest, especially seeing in view of the complex issues of caste problem and equation in society, they have taken it as if it is a war between two different groups. But in my approach, that is not true. And it has been clearly indicated by Honorable Supreme Court in its 29th January's judgment, where the Supreme Court has, double bench of the Supreme Court has stayed the order, stayed the order against the regulation of 2026 and called it that it is in vagueness, it is not fit for the society. Why that is so? Now here, as two words which are in the air, especially section two sections, two provisions of this regulation, section 3.6 and section 3E. Okay, section 3 talks about the caste-based discrimination, and section 3E about the discrimination, meaning of to these two sections. One another section is also to be taken into account, which I think that it would not have been taken into consideration by most of the peoples. The definition of the equity been given there. So if you have read the provision, section 3F, it clearly mentioned that if you see it, the equity means a level playing field. Sorry. So
Hello.
Hello. Hello. There looks like some connection issue. Hello.
There is a technical glitch. I think. Vagishi, are you there?
Yeah, Dr. Varghese, can you hear me? Hello. Ayush, can you hear me?
Yes, sir, you are audible. Let me call Vagishi. Just a second.
Yes, yes.
Just a second, I'm calling. He is joining in a few seconds. I would like to request the audience to wait for a few minutes. There is some technical glitch from the speaker's side, so he's joining in a few minutes.
Able to be connected.
Yes, sir, you're audible. If you could please turn on your video, sir. You're audible.
Oh, okay, okay. Now am I visible?
No, sir, you're not. Just a second.
Low network bandwidth. Low network. It shows low network bandwidth. एक
Yes,
मिनट
sir. Just- Kindly just wait for a few minutes. There is a technical issue and he's not audible right now.
ओके थैंक यू जब आ जाएगा सर तो वीडियो ऑन करिए ओके ओके अगर वो नेटवर्क सही रहेगा ओके ओके कैमरा बटन को ट्राई देखो Okay, I think, am I audible?
Yes, sir, you're audible.
Okay, now I am going on. Okay,
Okay, sir.
okay. So the thing is, I am talking about the definition of equity, which has been given under the UGC Equity Regulation 2026, and the definition is that equity means a level playing field for all stakeholders, which are incompatible with human dignity. So here, So whatsoever the definition has been given here regarding the equity. So and why the Supreme Court has said it vague, in my opinion, whatsoever I feel till now. So the definition in, if you have read the meaning of equity in the sense of equality under Article 40, you will found the definition which has been given here has been given a quite a different meaning. Why? Because equity means a level playing field. Okay, up to this it is good, but after that for all stakeholders. So here the stakeholder, whenever the word stakeholders has been used in the UGC equity regulation 2026, it is a narrow inclusion because it did not consider the student as a class. Rather, it tried to bifurcate them on the basis of their caste, religion, and other things. So the thing is that it is not a level playing, but what we can, and this is the things that why it has been mostly opposed by a segment of the people in society. They think that it is not fit for their so-called interest. Okay, why? Because they have seen it in the light of Article 14, and that's why the Supreme Court has taken it as vague. And furthermore, the same definition says that which are incompatible with human dignity. Incompatible with human dignity. So here I would like to connect it with Article 21. So human dignity. So here the equity regulation talks about the human dignity of a particular section of the society, but did not talk about the human dignity of other section. That's why the most of the criticism has been based on this definition of the equity, because the human dignity belongs to everyone. Under if we read Article 21, and especially after Menka Gandhi, so human dignity in everywhere, whether in substantive law or procedural law. So living with human dignity means a meaningful life. So meaningful life for everyone. And why it has been opposed? So meaningful life, so here the thing is that this meaningful life can be changed because the word which has been used, and if we have seen the definition of discrimination, where the it has been say use the word unfair. So what can constitute fair and what can constitute unfair? That is again not cleared by just by looking the various provisions or the definition clause of the Equity Regulation 2026. Okay, now the Supreme Court called the definition vague and capable. Why? Furthermore, the Supreme Court said that there is a probability of misuse of these provisions. Now we have living in a complex society. We, because the caste system of the in India, caste system is very much crucial, and it has been said that you can change your religion, but you cannot change your life, caste. You can change your religion, but cannot change your caste. So this is crucial. So the Supreme Court said that suppose there is a enmity between two person, two groups, two caste, or two segment of the society, and one is connected with other or some other person, so they can use it as a tool. So here the approach should be, what should be the approach? So harmonizing the competitive interest. So the law here, I would like to use the sociological school. I would like to use sociological school of law, which talked about the law as a social engineering and use law as a tools to harmonizing various competitive interests. So here what we found that there is various competitive interests in society. So how we can make a balance of this competitive interest? So here the work of the law, the purpose of the law to make a balance between different competitive interests And here what we see, that after coming into force of these provisions, after coming into force of this equity clauses, that there are so many huge cry. It is obviously, at the same time, it is obviously true, because after the Abeda Salim Tadwi vs Union of India case, in which in 2019 the Supreme Court issued a direction to make suitable provisions for these uh, oppressed class and depressed class of people of students. But at the same time, any law which shall came into force, okay, that law should not be a means or tool to create a fear or apprehension of fear in the mind of other segment of the society. So the Supreme Court here also tried to make a fine balance. I am not saying the balance. A fine, here the Supreme Court, what the Supreme Court wants, to make a fine balance. Why to make a fine balance? Because we are living in a complex society where the caste is a truth. One cannot deny. One cannot deny. Why I am saying so? If you have read Ram Manohar Lohia, Pandit Deen Dayal Upadhyaya, Mahatma Gandhi, B.R. Ambedkar, everyone accepting that yes, caste is the reality for the Indian society, and this caste is existing in our social life, in our social life. So if something is relating to our social life, that one cannot say that I am out of, I don't believe in this system. So this is the hardcore reality. This is the hardcore reality. And unfortunately, this practice, now I am using the word practice for this caste system. So it has been practiced by many of the people, many of the person, for their certain vested interest. And here vested interest flow from political motivation. This vested interest, so the common man did not have any kind of, if you walk anywhere in the society, if you walk anywhere in the society, just before coming into existence of this provisions, you did not found, I am not saying that complete discrimination, that there is no discrimination, but they are very few, but they are very few. And even whatsoever the number expressed or given or data given by them, that the total number of discrimination reported from 2020 to 2025 is 132 number of cases. And in higher education, and if we compare it at present time, the total number of enrollment in our Indian higher education system is approx 4 crores of students are enrolled in various higher education institutions of the central universities, of the state universities, of the private universities, and other universities of national importance. So out of these 4 crore students, if I am not supporting or opposing anything, if 132, whatsoever the data reported, whatsoever the data reported, or it has been on record before the Supreme Court, 132 number, I'm not appreciating, but this number is, if you have counted this number in percentage, this is a negligible 0.00012%. Okay, so the thing is that the discrimination is there, but this discrimination is not at such which can be which can be taken ignored or can be taken as a ground for just supporting regulation. Why I am saying so? Because at the same time, if we see that various data from the higher education institution where the other segment, other class that is of the general category of students, are at stages some stages they are being subject of this type or that type of discrimination. So here whatsoever like to be done, so here the thing is to make a balanced approach, why? Because the regulation, after coming into force of this regulation, an important question has been came into air, and the question is that whether the regulation are a step forward or a setback for Viksit, Bharat vision of Honorable Prime Minister. So now the thing is, whatsoever we want to be ourselves a Bissu Guru. We want that our higher education institution up to be a world class institution. And if we are talking of something which, in my opinion, is not a welcoming thing. Okay, why not a welcoming thing? Because everyone, those who are in favor of or in opposition of the UGC equity regulation 2026, just whatsoever they are doing, they are playing their own interest. They want to root their own interest, and by employing their own interest, just they want to do their own politics. So whatsoever the object behind this equity regulation, the object behind equity regulation is to remove every kind of discrimination, to remove every kind of discrimination from the field of higher education institution, so that to make the Bharat as a Bisuguru, so that to make the Bharat as a Biksit Bharat, according to the vision of Honorable Prime Minister of India. But what we found, rather to remove this discrimination, rather to talk about how to remove the discrimination without being committing any kind of discrimination with any segment of the society, with any class of the students of the society. The thing is, now the equity regulation itself is in question, is itself in question. And here the role of Supreme Court is now very much crucial. Why crucial? Because the Supreme Court, the remarks made by the Honorable Chief Justice of India, Justice Surikant, is very much relevant regarding it, because it is on the line of Biksit Bharat 2047 mission, because we are living in 21st century, and we are talking about century back some misfortune, mishappiness, which cannot be acceptable. It, rather to bridging the gap, in my opinion, it has widened the gap. So here the attempts should be made to bridge the gap. And here, let us hope that Honorable Supreme Court will give a welcome decision in the upcoming time. The next hearing, that is on 19th March 2026. And the Supreme Court is also apprehended that these higher education policies, they should not be shaped by abrupt and arbitrary changes which has been made by the policymaker. And when we are comparing with the policy of 2012 and the policy of 2026, now we found that something which should not happen is happened with this regulation. Okay, so the Supreme Court wishes that before that this regulation should not bring instability, eh, and furthermore weaken the institutional foundation. Why the institutional foundation? Because it has the potentiality to break the brotherhood, to break the brotherhood in the higher education institution. Just I am giving one of the illustration. I have spent my all of the higher education study from the Banaras Hindu University, where I live with the students of different community, especially belonging to the scheduled caste and scheduled tribe. And still today, we are living in very good friendship position. We don't have any kind of doubt or apprehension in our mind. But can you imagine with those students who are just a newcomer for the higher education institution and coming with this apprehension in their mind that something wrong can be caused with us? So this question is relevant for both sides. I am not posing this question for one side. This question is relevant for both sides. Now both sides are coming having the apprehension in their mind that some misfortune or mishappening can be happened with us due to some reason. Okay, one is that one comes with this notion that person of general categories or other castes are prominent in the higher education institution and they can discriminate with us. Other comes with this discrimination that look, this regulation came into force, and as a consequence of this regulation we can be trapped. So here apprehension exists from both sides. Apprehension exists from both sides. So here the role of law is now very much crucial. Okay, now the thing is, that again it is a question of justice also. In the field of law, if you are making any law, and if the law is not with the end or to fulfill the justice system, because in end of law, at the end of law, the subject matter of the law, end of the law, outcome of the law is to provide justice. So here the apprehension in the mind of both sides that there shall be injustice, and here the policymaker shall take into consideration the justice delivery system, the justice delivery system for this higher education institution, for the stakeholders of these uh, for this system and the stakeholders. Now here the question, now the word stakeholders has also been used in the regulation. So here the stake, why the Supreme Court said that this is a way. So here regarding the complainant, a narrow approach has been adopted. So with respect to the stakeholder, so the people who are coming from the general category, they are also the stakeholders. The faculty who are coming from the general category, they are also the stakeholder for the higher education institution. So the concern of everyone shall be taken into account. And if the concern of everyone shall not be taken into account, then it might not be served the justice, and it amounts to denial of justice. Furthermore, why I am saying the denial of justice? Because the provision, the regulation lack the provision regarding the false complaints, and in the experiences says that in the experiences of the past time says that in the past years what we have witnessed, that the social legislation or the beneficiary legislation which has been made. Just take the example of Atrocities Act or the Dowry Prohibition Act or some other beneficial act. They have been misused and has been used as a means to create deterrence in the mind of opposition, opponent, to make them blackmail. That's why a reasonable apprehension. That's why a reasonable apprehension. So I think this fact shall be in the mind of Supreme Court. That's why the Supreme Court said that this is a vague, that this is a vague term and not suitable to the Indian scenario or the Indian condition. Why not suited? Because it has the potentiality to divide the student. Now the Supreme Court has taken a student as a community. Whatsoever the Supreme Court approach here is to consider the student as a one unit. So you can make a law, and the approach is reasonable classification. Whatsoever the law made for a class or segment of the society, that shall be a reasonable classification. So here the class is a students. The Supreme Court said that do not try, the remarks made by the Honorable Chief Justice of India, do not try to divide them, because we are living in 21st century, and any act or attempt to divide the student would create hurdle for the development of the society, and ultimately it will create a hurdle for the Viksit Bharat vision of the Prime Minister and the vision of the forefather. Now, whatsoever the vision of the forefather here, one more thing I would like to add, that vision of the forefather is casteless society. Caste, though they did not, it did not expressly mention in the provision of the constitution. Just you can take the, one can ask that like the provision of evolution of untouchability, if this is the vision, why the forefather did not include the provision for the abolition of the caste? Yes, I agree. They said that there are two things, one is caste and another one is casteism. So they say that you can practice your caste without being creating hurdle or inconvenience to other section of the society by standing on same footing, by standing on same footing. So the thing is, whatsoever they want to prohibit, they said that this casteism, that ism, because it gives a kind of unnecessary proudness. If we read V.R. Ambedkar, he is of the opinion, he is of the opinion that unnecessary feeling of the proudness regarding caste can destroy the fabrics and brotherhood of this country. So he said that the rights must be reached to that section, to that segment of the people who has been oppressed or depressed from long, long back. And while you are empowering them, this is the remarks made by V.R. Ambedkar. While you are empowering this oppressed or depressed class, any attempt should not be made to make underprivileged to other section of the society, to make them
Dr. Upadhyay, if you can just
underprivileged.
Dr.
Okay.
Upadhyay, if you can sum up, we can have some
Yeah.
discussions also. There are a few questions also. So maybe in 2-3 minutes time, if you can
Okay.
sum it up. Yeah.
Okay, sir. Okay, sir. Thank you, sir. So I would like to sum up in these words. So The justice in education is not about favoring one group over another. It is about creating a system where dignity, merit, and fairness coexist. So, UGC Regulation 2026 will only succeed if they protect the vulnerable without criminalizing the honest, empower students without instiling fear, and promote equality without deepening divisions. Inclusion should build trust, not tension, and the strength of these regulations will be measured not by their intent but by how fairly and wisely they are implemented. So again, the question is regarding the intention and intensity of the act, how it could serve the purpose, and it has been cleared by the Honorable Supreme Court in the case of Aveda Salim Tadwi versus Union of India in 2019. And I hope that in upcoming days we will see a balanced regulation enacted by UGC regarding promoting the equality in higher education institution. With this word, I am summoning of my today's submission. Thankful to
Yeah,
everyone for
yeah,
kindly hearing me.
yeah. Thank you, Dr. Upadhyay. We have a few questions. So,
Yes,
um, yeah, I think the first question which has come from Anirvan Deshpande, he want to know, the question is, we are repeatedly witnessing general caste students, especially Brahmins, being hated and discriminated in campuses. Brahmin Bharat Choro, Brahmanbad Se Azadi, Tilak Taraju और तलवार, इनको मारो, जूते चार. These type of slogans have been normalized. Hate against general caste can be visible in social media platforms too. So why can't the UGC include general caste too and make it inclusive in nature? That is a question, Dr. Upadhyay.
yes, sir. Yes, sir. Uh, so my submission is that the thing is that these slogans which were earlier we have seen in the JNU campuses and previous day in the BHU campuses also. So these slogans have been raised by very few numbers of students, and those are the politically motivated or guided from somewhere, and their intention is to create tension and to break the harmony, brotherhood which has been existed in the society, and it can be removed only by creating awareness to bring some of the facts just uh, uh, whatsoever happened. Just I am not quoting anyone, any of the journalists. Some days back in Delhi, what happened everyone knows. So when that journalist asked, who stop you to drink the water? So remarks is that people from a particular caste stop us. Then her next question was, then why you have not dug another wall for yourself too? So a narratives here, whatsoever I want to say, that a kind of narratives, a kind of narratives is being set up, and the thing is that we awake up late, यानी हम लोग देर से जागे हैं. हमें कुछ और पहले जाग जाना चाहिए था. सरकारों को, समाज के जो सिविल सोसाइटीज हैं, उनको थोड़ा और पहले जाग जाना चाहिए था और इस पे काम करना चाहिए था, सो दैट देयर कैन नॉट बी एनी social tension by these slogans, is social tension, and these kind of peoples are successful in their attempt to bring a social tension. in the society. And by this, they are also posing law threat to law and order situation of the country. Because if once a social tension erupted in the society, ultimately it is a question of law and order. So this kind, I strongly condemn this word, any kind of hate speech, any kind of hate speech, whether for this part of the society or for that part of the society. And this can be done only with the implementation of law. If law, just if law will, if an FIR will, those who are aware, they have to come forward and register the FIR against this person who are bullying the other part of the society. And by booking them under the various provisions of law, we could surely will able to establish law and order situation, a Biksit Bharat according to the vision of Honorable Prime Minister, according to the vision of our founding fathers also. Yes, sir.
Yeah.
Namaste,
Thank
Vagish.
you, Doctor.
Namaste,
Yeah.
Vagish ji.
Thank you.
I am Anirban. I asked the question. Okay, can I follow up with this? Actually,
Yes.
the thing is, I come from an OBC caste, but the thing is, I have seen in the college campuses when I was a student. Actually, I'm in masters now, so I have seen my Brahmins and Rajputs friends getting humiliated with terms like Ponga Pandit and Mughal Poots, etc., etc. We all came across these terms in social media and also in the real life too. Dhongi Pandit, etc., etc. So the thing is, ki the hate is real for the general class too. So if the UGC can be, if the UGC includes these categories, the general category too, that will be a truly inclusive law, right? That will not omit down the rights of other general castes. So that is my question.
Yeah, right. I think we have one more question, Dr. Upadhyay, because we have limited time. So if you can take this question also, and then probably we can talk it together. So this second question is by Srikant Sridhar. And the question is why the Indian Constitution was seemingly an assembled structure instead of a gradual integration for all. For all politicians who ask for reservation in institutions, why can't they lead the way by giving representation to all castes? Because all I see here in the UGC issue is nothing but a symptom of long rot from the Government of India Act 1935. That is the question, Dr. Upadhyay.
Vagish, are you there?
Hello. Yeah, Dr. Upadhyay.
Hello, Vagish, are you there? Let me call him. Just a second.
Yeah.
He's having some technical glitches. He messaged me now. Just a second.
Okay.
He's rejoining.
Okay. I think by the time Dr. Upadhyay joins,
Yes, sir.
I think I just have a few observations. And probably even audience can reflect onto that. Um, thing is that we all know the caste system is a millennium old problem which India is carrying, in fact. But thing is that how long we can carry it forward. Um, that is one thing. Secondly, when from millenniums to we have reached to this 21st century, still our academia is dominated by these sort of debates, and even the political class actually, that is we consider that party system structure is centered on the caste issue. So when we can somehow get rid of this sort of divide, that is a very serious issue, because the way it has been fomented in the British time as part of the divide and rule policy of the British, somehow this is being carried out, all throughout still today. So I think it's high time, some sort of a strategy or some sort of awareness is so important. Um, and I just have one, suggestions to make. Probably all of the people, those who are assembled here, should talk in terms of science, because you just see 2008, the scientists have gone for a human genome project. What was the finding of this human genome project? That was the major finding was that every people on this planet, they are exactly same at the level of gene or whatever you can see, right? So all such discrimination in terms of the caste, class, community, race, these all are actually the all false, walls which we have created, in fact. Right? And this sort of awareness is required. As a teacher, we have to tell the students, in fact, that there is no relevance of, keeping all such divide, in fact, and wherever is possible, this is our very significant duty to create an awareness against all such divide, in fact, right? So that is probably one suggestions from my part.
Yes, sir.
Um, Dr. Upadhyay, if you join.
Yes, sir. Sorry for technical glitch.
Yeah, Ayush, whether Dr. Upadhyay has joined?
Yes,
Yes,
sir.
sir. He has joined.
Okay, okay.
Yes, sir.
So
Yes, sir. I am joining.
just the last few words, we will then sum it up, in fact. Or should I say this as a, just concluding remark, because this is an issue which has to be seen in a more comprehensive manner, because why the young people got agitated, that is somehow somewhere that sort of perception, has been generated, in fact, right? And that's why I just said that this is our very significant responsibility on our part, that an intense awareness is required, in fact, regarding all such divides. So, in the end, yeah, if Dr. Upadhyay, if you have anything to add, or otherwise, I will just, close this.
No, no, sir. Just yes, sir. Yes, sir. Just conclude. So you can conclude.
Okay, okay, right. So I have just sum it up here, right, from my part,
Yes, sir.
by saying that why, this sort of awareness is required, in fact, so important. So I just would like to thank Dr. Upadhyay for putting his inputs on this issue of
Thank you, sir.
immense importance, because it matters a lot, and how it led to this agitation, primarily confined to North India, especially in Bihar and Uttar Pradesh. Mostly this agitation has been witnessed. And this somehow also refreshed my mind when I joined my studies in Banaras University in 1991, and the way the Mandal agitation that time has created. So definitely, this agitation is nowhere near the type of agitation which Mandal has generated that time. But definitely, this has caused concern, because somehow, the political class as well as the Supreme Court has taken more active role somehow to, deal with this issue, and that's why the problem has been also uh, somehow we can say that yes, it resolved, but I think in long run time, it becomes a responsibility on our part, everyone, right, to be part of this awareness, program, and drive a sort of concerted action against the caste consciousness. In fact, caste money, because there's no relevance of this, that has to be required. So I just would like to thank Dr. Upadhyay for his input again, and just sum it up. Yeah. Thank you everyone for joining. Thank you, Ayush. Thank you,
Thank,
NRS.
thank you, sir. Thank you, sir,
Thank you.
for
Thank
giving
you.
me this opportunity.
Thank you very much.
Thank you, Vagiji. Thank you, Om Prakash ji. Thank you.